Okay, so we're live on YouTube. Thank you very much, everyone, for being with us on a Saturday morning. And thank you very much, Professor Fine. Let me just do something here. Okay. And should I call you Tony?
Tony, please.
Okay, thank you. So Tony, it's a pleasure to have you here at Descomplicando Inglês Jurídico again. Tony and I met in 2018 when I went to Fordham Law School to take an American law course for foreign lawyers. And she's the director of the program. So that's how we met. And she also teaches students at Fordham, so she knows everything about the court structures of the US, and she teaches the subject really, really well in a very simple but not simplistic way. You're going to see that in a few minutes. So let me introduce Tony to you. Let me read her bio, and then she'll start her class. So Tony Jager Fine is an assistant dean at Fordham Law School in New York, where she teaches a range of degree and non-degree programs. Prior to her time at Fordham, Tony worked at NYU, where she taught lawyering and was associate director of the Global Law School program. And at Crowell and Morin, where she worked primarily on commercial and administrative litigation, including practice before the U.S. Court of Appeals. She is a member of the New Law Institute of the Bar Association of the City of New York. Tony has written a number of articles and books on a wide range of topics, including becoming a lawyer, discovering and defining your professional persona. She blogs at yourprofessionalpersona.com. Tony travels, or used to travel, and we'll be back to traveling extensively, and has taught or given lectures in numerous countries around the world. Tony comes to Brazil frequently also, right, Tony? We have met already, right, in Brazil. Yeah. Law firm. So welcome one more time. And for those who are watching us, Tony will speak for about 30-40 minutes. And that any questions you may have, please feel free to write them in our chat. So we're going back. Okay, let me see if we're back again. Yes, it seems everything is okay now. Sorry, well, it happens sometimes.
Often
So,
it happens, yeah.
yeah, so let me double check everyone. It's back now. Excellent. Thank you guys for your feedback. So Tony, the floor is yours, and we'll talk again in 40 minutes, 30 or 40
Great.
minutes. Thank you.
Thank you so much, Bruna. I know that when I met Bruna 2 years ago, I was so impressed by her as an individual and by this Descomplicando. I know I said that very poorly, but this project she's been working on. So whenever Bruna asks me, will I do something with her on Descomplicando, my answer is also immediately, yes, I would love to. What I also would like to tell everyone, as Bruna had mentioned, that I do visit Brazil often, or at least I did. I guess it's been a little bit more than a year since I've been there, so I'm very anxious to get back. And I will get back as soon as it's safe and advisable to travel again. And I hope that I'll get to meet many of you in Brazil, and that I'll get to meet many of you also in New York. I'm going to share my screen now, and I hope that everyone can see that. I will assume that Bruna will let me know if there's any problem and you don't see it. I heard Bruna say that you can ask questions in the chat. What I prefer to do, if that's okay, is I'll take all the questions at the end. So you can write chat comments or questions anytime, but I will respond to all of them at the end. And I want to start with my email address, because I hope that for many of us, this can be just the beginning of a dialogue, and that if you have questions later, or you're interested in studying in the US, or whatever it may be, that you feel free to reach out to me, and we can continue to talk. And so I'm going to give you this introduction to the US courts, as Bruna said, and I'm going to focus on the federal courts. This is really a talk about the federal courts, but I wanted to say at the outset that we, like Brazil, we are a federalist system. And so one of the things I love about having Brazilian students is they always understand federalism. Students from many other places around the world, when you talk to them about this concept of federalism, it's very, very strange to them. And it maybe even seems strange to us, but at least we understand it. You will find, if you were to study more, that the US system of federalism is quite different from the way that the federalist system works and operates in Brazil. But you understand the general concept of federalism as being a government based on shared governmental powers. So rather than having a centralized system, as in the case in many other countries, in the US, for example, there's the federal government that has some responsibilities, and the remaining responsibilities fall to the states. And so the federal government in the US is a government of very broad, but actually limited powers. And in the US, the federal government is a government whose powers are limited to those that are enumerated in or listed in the Constitution. So one of the things I always like to use to demonstrate, I'll pick up, this is just my notebook, but imagine that it was the Constitution. And if Congress wants to pass a law, Congress actually has to look through the Constitution and find a source of authority that allows it to do something. The same is true for the executive branch. When the executive branch wants to do something, it must find a source of that authority in the Constitution. And the same is true with respect to the judicial branch. When the courts want to do something, or before doing something, the courts must ensure that that something is consistent with its constitutional power. And so we have, of course, a federal judicial system. This is my introduction into the court system. The federal system is a product of federal law, federal constitutional law, and federal statutory law. And that's what we're going to focus on today. But I do want to say a few words now and a little bit later about the 50 different state systems. And here you'll see it's 50 plus independent and autonomous state court systems. So the US has 50 states, and we have a few territories that are not properly states. So DC, the District of Columbia, is not technically a state, it's a territory. Puerto Rico is a territory, not a state. They act like states in most respects, but we just really think mostly about 50 states. In each of those states, there is an independent, sovereign, autonomous state court system. And each of these systems is the product not of federal law, but of state law, state constitutional and state statutory law. And so what you have in the US, and I believe this is different from how it functions in Brazil, is you have variations that are sometimes significant from state to state. So the New York state courts will be structured in a particular way, and judges will be chosen in a particular way. And the jurisdiction will work in a particular way. Whereas the California courts might be very, very different. There are lots of similarities between and among state court systems, but there are and can be significant differences from state to state. We'll revisit that a little bit later, but we're really going to focus on the federal court system. So I'm going to just dive right in and tell you a little bit about the federal courts, how they function, how they operate. We're going to start with a discussion of how federal court judges are chosen. And I think as I go through a lot of this, you'll nod in agreement with certain things that are familiar from the Brazilian system, and then you'll be, as with respect to other things, completely mystified at how different the US and the Brazilian systems are. So with respect to federal judges and the selection of federal judges, first, it's important to note that there are no constitutional qualifications. And this is interesting because when it comes to becoming a member of Congress or becoming president, there are some very minimal qualifications. There are no qualifications to be a federal judge as a matter of constitutional law. So the examples I like to give is say, well, I could be a federal judge, you could be a federal judge. As a matter of constitutional law, my 9-year-old niece could be a federal judge, and your grandmother, who maybe isn't educated, maybe doesn't speak English, or my grandmother, for example, who also was not educated, although she did speak English, she was a native English speaker, she would have been constitutionally eligible to be a federal court judge. So there's no constitutional qualifications, but the selection procedure ensures or helps to ensure that federal judges are at least reasonably qualified. And in most cases, I have to say, I think our federal judges are quite good. I don't think the same is true of all of our state judges, but the selection procedure is a very public one, and it's a very politically oriented one. So some of this I think will be familiar. Federal judges are nominated by the president. They then go through a process of confirmation by the Senate. The Senate is required by the Constitution to give what's called advice and consent. And that's known, we refer to it as a confirmation process. And once that person is confirmed by the Senate, the appointment is made by the president. And so this is obviously a totally political process, which in fact has become increasingly politicized in recent years. You may recall, depending on how long you've been interested in these kinds of issues, I'm sure Bruno recalls that we had a very conservative justice die a few years ago during the term of President Obama. And the Republicans in the Senate just refused to confirm the person that he had nominated. They refused to act on that person at all. And so for nearly a year, approximately a year, we just did not have a member of the Supreme Court. There was no way to force the hand of the Senate in making that confirmation. So it is a process that is political and increasingly politicized, but we also have a very, very strong tradition and very strong requirements of judicial independence, which means that although the process is political by which a judge gets selected, once that person is in office, she will enjoy complete judicial independence from the political branches. So what that means is the president can't touch her, Congress can't touch her. How? Because the Constitution provides first that once you are a sitting federal judge, your salary cannot be reduced. Okay, your salary cannot be reduced. So imagine if I were a federal judge earning, let's say, $200,000 a year, and if Congress or the president didn't like a decision I made, they could simply reduce my salary to $5 a year, Well, that's just about the same as firing me because I can't live on $5 a year. So my salary could not be touched once I'm a federal judge. And federal judges get to hold their tenure. They get to hold their position as a federal judge in the language of the Constitution during good behavior, And that has always been interpreted to mean that that federal judges have life tenure unless they are convicted of an impeachable offense, okay? And this is something very, very serious. I don't know how impeachment works in Brazil, but it's very, very hard to impeach and certainly to convict a federal judge. And it's very, very rare. It's very, very unusual that a federal judge is impeached or, for that matter, convicted. So basically, we think of federal judges as having life tenure. There's no maximum years of service. There's no retirement age, as I believe there is in Brazil and most other countries. And so we had a member of the Supreme Court step down some number of years ago. He was 90 or 91 years old. I knew a Court of Appeals judge who unfortunately passed away recently, but he was still on the bench at 94, 95, maybe even 96. You could question whether this is a good idea or a bad idea, but you can certainly see how this life tenure and the no diminution in salary help to contribute to judicial independence. The federal court system is highly decentralized, which means that there is not much meaningful control by higher courts over lower courts. They control lower courts, certainly higher courts control lower courts when it comes to precedent and rules of stare decisis, what you would think of as my Portuguese is non-existent, so I'm going to say this and I'm going to say it very poorly, but your closest equivalent, the súmula vinculante. So in that way, higher courts control lower courts, but there's no managerial control of any sort. And in fact, judges themselves have a tremendous amount of independence and autonomy. The federal courts are courts of limited jurisdiction, and this is something we'll speak about a little bit in just a few moments. What does that mean? It's consistent with the concept that we spoke about at the outset, which is under a federalist system, there's this power sharing arrangement between the federal government and the states. And so while the federal courts have certain powers, they share that power with the states. And so it is not true that you could bring any kind of case to the federal government. You have to have you have to have met a couple of different jurisdictional requirements. And my guess is that is very much the particulars will vary between US and Brazil, but the concept is probably familiar to you as federal courts as being courts of limited jurisdiction. At the same time, the federal courts in the United States are courts of general jurisdiction. At least the vast majority of them are courts of general jurisdiction. What that means is that we have very few specialized courts at the federal level. So I know that in many countries, and I think probably to some extent, at least this is true in Brazil, I know it's true to some extent in Brazil, you might find commercial courts, criminal courts, electoral courts, labor courts. In the US, when you meet a federal judge, 95 out of 100 of them, depending on how you define what a federal judge is, will be judges in courts of general jurisdiction. So they are not specialized courts. They'll be hearing electoral cases, and they'll be hearing commercial cases, and they'll be hearing state law tort and contract claims, and they'll be hearing intellectual property claims, and criminal cases, and so on and so forth. And again, we could debate whether that's a good system or a bad system, but it is the system that we have. The federal courts are organized along both a hierarchical basis and a geographical basis. When it comes to hierarchy, the courts are structured to look like a pyramid with 3 tiers. And in a couple of slides, or perhaps the next slide even, I'm going to show you what that pyramid looks like. I think a few more slides, you have to hold on just a couple of more minutes. And the courts are also organized on the basis of geography. Obviously, the US is geographically enormous. I think actually the continental US is about the same size as Brazil. You're more north to south, we're more east to west, but I think that pretty much our countries are the same size. And so we have various districts and circuits divided throughout the nation, which helps us organize the federal court. So let's talk first a little bit about the hierarchy of the federal court system. If you read Article 3 of the Constitution, and I would really urge you to read the Constitution of the US. Obviously, everybody on this call is at least a little bit interested in US law. Read the Constitution. If you're not yet quite comfortable with your English, there are Portuguese versions available. And so I would urge you to read the Constitution. And the courts are empowered and organized by Article 3 of the Constitution. And what you'll see is there's very little detail about the organization of the court. What Article 3 says is there shall be one Supreme Court and other inferior, meaning lower level courts, as Congress shall from time to time ordain and establish. So the Constitution establishes only the Supreme Court and delegates to Congress the power to create lower courts. So we could not have a higher federal court. So in Brazil, I always get confused with the names of your Supreme Court versus your Constitutional Court, but you have a Supreme Court, or at least the Supreme Court equivalent, and a Constitutional Court. We only have a Supreme Court. We could not, without a constitutional amendment, have a constitutional court. The Supreme Court must be the highest federal judicial authority. And then Congress has created a network of lower courts. So if you think of that pyramid, and we're going to get to it in a moment, at the very base of the pyramid will be what's called the district courts, the US federal district courts. And these are trial level courts. Most cases, almost all cases, with one exception that I'll mention in a moment, start in the federal system at the district court level. Then we have in the middle of that pyramid the courts of appeals, and these are intermediate appellate courts, and they are primarily geographically based. And so you'll see on a chart I'm going to show you in a few more slides, they're divided along the country. Primarily, they represent regions. We're going to talk about what those regions mean. And these are the intermediate appellate courts. And the courts of appeals' primary job is to hear appeals that come from district court cases. They also hear some cases on direct review from agencies. So administrative agencies are part of the executive branch, and they make decisions interpreting and applying certain legislation. In some cases, by statute, those decisions made by the agency are allowed to be brought or required to be brought directly in the Court of Appeals in the middle, rather than returning to the trial level courts, the district court. So let's take a look first at the hierarchical structure of the federal courts. And let's just start here at the trial level courts. They're called the district courts. They're known as the US district courts. There are 94 of them, and we're going to take a look at a map in a couple of minutes that will show you how these are dispersed. But there is between 1 and 4 of these district courts in each state. And Congress has decided how many district courts in each state based on Congress's assessment of how much judicial business there'll be in a particular state. So one thing you're going to see on the map I show you in a couple of minutes is New York is geographically not an enormous state. It's a big state, but it's not enormous. And we have 4 district courts. Why? It's a pretty populous state. It's a port. It's also got Wall Street. So there's a lot of judicial business in New York. So we have 4 district courts in New York State. You're going to see some other states that are very, very large geographically, enormous states in the West in particular, and they only have 1 district court. And that's because although they're very big, they're not as commercial as a state like New York or California or Texas or other states. And the population is not as great so as to justify more than one district court. Then in the center, you have your intermediate appellate courts, the courts of appeals. Sometimes they're referred to as circuit courts, and there are 12 of these, or 13. Once I had a student who said, well, could you look it up and tell us which it is? Is it 12 or 13? Well, I know the answer to it. It is 12 geographically based courts of appeals. There is one court of appeals that is a specialized court of appeals in the federal system. So although I told you that most federal courts are courts of general jurisdiction, that is not always the case. And there is one federal court of appeals that is a specialized court. But for most people, 99.9% of lawyers and individuals only deal with one of the 12 geographically based intermediate appellate courts. And then, of course, there is a single Supreme Court. That is the federal court of last resort. Let's talk just a little bit about the geographical structure of the federal courts. So as we highlighted in the prior slide, the nation is divided into these federal judicial districts and circuits. There are these 94 judicial districts. Again, each state has between 1 and 4, and there are these 12 regional circuits. And the concept of a circuit is actually very, very important. A circuit, I like to think of a circuit as a geographic region that contains one court of appeals and some multiple number of district courts, okay? And that concept of a circuit is very, very important for the operation of rules of stare decisis, which we're not going to talk about today, but this again is our version of summium vinculante. And it's also really important for judicial administration, because when you appeal from a district court, you must appeal to the Court of Appeals that covers your circuit. And I'm going to show you this in a moment on the next slide. It will be much clearer. And so then there is a single Supreme Court, which of course has nationwide jurisdiction. And so here's the map that I've been talking about that demonstrates the geographical structure of the federal courts. And if you take a look, one of the things I like very much about this map is that the colors are very bright and very bold. So it's very easy to distinguish them. And each different colored block represents a circuit, okay? And so let's look at the west coast of the United States because it's the easiest to see, it's the biggest. This is the Ninth Circuit. How do I know that? I know that because of this white number with a black circle around it that says 9. And that represents that's the Ninth Circuit. So the Ninth Circuit, it consists of the US Court of Appeals for the Ninth Circuit, plus all the district courts that fall within this green area, okay? All these district courts. Now, take a look at states like Arizona, and by the way, just as I would not be able to name the Brazilian states, more than a few of them, I would not expect you to be able to name all 50 states in the United States or understand these abbreviations. But if you could see my cursor, it's hovering right now over AZ, Arizona. Arizona is large, yet there are no dotted lines through Arizona as there are through California, which signifies that there's only a single district court in Arizona. The same is true for New Mexico, Colorado, Kansas, Nebraska, Wyoming, Utah, Nevada, very, very large states geographically, but they only have a single district court. If you look at California here, it's a little bit hard to read, at least for me. You see that it's divided into 4 districts: the Eastern, the Northern, Central, and Southern. And so there are 4 district courts in California, as there are in Texas, as there are in New York. And you could see some other states are divided into either 2 or 3 district courts. And again, there are a number of states that have only 1 district court. Remember again that when you appeal from any of the district courts in this green area, any single one of them, you appeal to the US Court of Appeals for the Ninth Circuit. And so your 12 geographic courts of appeals are numbered 1 through 11. And then the 12th is this one here that says DC. Now, this happens to be an official government publication map, but if I were designing this map, I would have written DC in white with a black circle around it, and I would have done the same thing here where it says Fed to signify the 12 geographically based courts of appeals and the one specialized court of appeals. I want to go back to the concept of the federal courts as courts of limited jurisdiction, of limited competence. And this, remember, goes back to the whole concept of federalism. The whole premise of federalism is that governmental power is shared. And so as a result of federalism, you can't put all the nation's judicial power in the federal system. The federal courts have to share the judicial power with the states. And so when you look at Article 3, and I really do hope you'll take some time to read the Constitution, you'll see that it starts with the words, the judicial power shall extend to, and that's referring to the federal judicial power. And we're going to talk about what these limits are in just a moment. But I do want to say what happens if there is no competence in the federal courts. If I sue somebody and I bring that claim into federal court, if the federal court determines that it does not have competence over the matter, it can do nothing other than dismiss the case. It must dismiss the case. It does not have the authority to do anything other than dismiss. And this is because it goes to the actual authority of the court to hear a case, it may not be waived by the parties. It may not be sort of ignored by the court. The court can do nothing but dismiss. And it is also one of the few areas in the US in which the court will raise the objection on its own. So if I sue somebody in federal court and we both kind of think that the federal court maybe does not have jurisdiction, but we decide we don't want to talk about it, we don't want to complain, the other side doesn't raise an objection, that doesn't resolve it because the court should and will raise that objection or raise that concern on its own motion. And US courts tend to be very reactive. They normally do not raise objections to things, but when it comes to its own competence, this is an area where the court will actually raise a concern on its own motion. There are two large categories of limits on the competence of the federal judiciary. The first is what's called subject matter jurisdiction. And what this means is that certain kinds of cases cannot be heard by the federal courts. And in fact, for the federal court to have subject matter jurisdiction, it must, how shall I say, it must meet some sort of a jurisdictional handle. There's a certain categories of cases or certain things you must find about a case in order to have federal court subject matter jurisdiction. Every other case must go to state court. Okay, so the subject matter jurisdiction. And the second limit on the competence of the federal courts is what's known as justiciability. This is probably a word you're not familiar with. No matter how good your English is, this is just not a word that normal people use. This is a term of art. And as far as I know, it really means only one thing, and that is whether a claim gives rise to a case or controversy within the meaning of the Constitution. These are words in Article 3. It says that the federal courts can hear only cases or controversies. And we're going to talk a little bit about what that means. So let's first take a look at federal court subject matter jurisdiction. Which kinds of cases can you bring into federal court? Well, first, you could bring a case into federal court if the US is a party. If the United States is a party, the claim may be brought in federal court. Second, when there is something that we call federal question jurisdiction, it's also sometimes called arising under jurisdiction. When a case arises under a federal question, whether it's constitutional or statutory, the underlying cause of action is based on federal law, constitutional, statutory, regulatory. It is the federal courts have federal question jurisdiction. So you have to look at the underlying cause of action. Diversity jurisdiction is very different. It doesn't look at the kind of controversy at all. It looks at the nature of the parties and the amount at issue. And so there are two requirements, both must be met. One is that the parties are citizens of different states, or a party who's a citizen of a US state and a foreign country. And there must be more than $75,000 in controversy. The notion behind diversity jurisdiction, and remember that the questions arising under diversity are state law questions. Why do we allow them to go to federal court? We want to eliminate any concern that an out-of-state defendant may have that he feels he's being treated unfairly. So we let cases involving a certain amount of money to go to federal court when there's a diversity of citizenship to bring it to a more neutral forum. I'm taking a little too much time, so I'm gonna skip a couple of things. The second limit on the competence of the federal judiciary is the case or controversy requirement. And this asks three independent but related questions. First, let me just step back for a minute and say this. The concept of the case or controversy requirement is to ensure that the federal courts do not give advisory opinions. So for example, there is no pre-enforcement review of legislation in the United States. So the three doctrines that comprise justiciability are first, standing. And standing asks whether the plaintiff is the proper party to bring the claim. And so let's imagine that there's some law that's passed by Congress, signed into law by the president, and I, as a constitutional law scholar, think that this law is unconstitutional. But it doesn't affect me directly. I cannot bring the litigation. I do not have standing, because in order to have standing, I need to have a direct, that law needs to have a direct and immediate impact on me individually. And I can't just say, oh, my sensitivity or my sensibility as a constitutional law professor is affected by this. So we have to look for someone who is directly affected by the law. Second, the law cannot be challenged before it is passed. So this is the question of ripeness. The claim must have matured to a point where it is an actual case or controversy. So let's say that Bruna and I have a contract, and she's supposed to send me, you know, you Brazilians do a great job with these, like, you have really nice perfumes and skincare and soap and lotion. I love Brazilian, it smells so good. And so Bruna and I have an arrangement that once a month, she's gonna send me particular things, nice smelly things from Brazil. And then one month, someone tells me, you know, Bruna is not gonna be able to make the shipment next week. And I run to court and I sue her. And I say, well, the contract is due in a week or two. No, that is not ripe yet. We have to wait for the obligation to occur. We have to wait for some failure on the part of the would-be defendant. You can't anticipate legislation. And as I said earlier, you cannot ask for pre-enforcement review. And finally, the doctrine of non-mootness asks, is it too late? Because again, the goal of the case or controversy requirement is to ensure that courts do not hear advisory cases, cases that are not real, live, actual cases. So if Bruna and I have a dispute, but then we settle it out of court and make an agreement, but we say, gee, this would be fun to go to federal court, put all this stuff we've been learning into action, let's keep going and just have the litigation for fun. No, the court will not entertain claims that are that have become mooted by subsequent events. I just want to remind you that each state has its independent, autonomous court system, which is the product of state laws and will sometimes be similar to the federal system, very often is, sometimes be very different. And along with that, and I think this is different from the way it works in Brazil, is that in the US, each state will have its own rules of procedure. its own rules of evidence, its own court structure, its own process of judicial selection, its own rules of jurisdiction. It turns out that most, if not all of them, are structured like the federal judiciary, at least in broad outlines, where you have 3 tiers of courts. But again, that is not a constitutional mandate. That is up to each individual state. You do at the state system tend to see far more specialized courts than we see in the federal system. So in states, again, it will vary from state to state, but it will be very common to see criminal courts, family courts, probate courts, juvenile courts, traffic courts, small claims courts. So it is common to see more specialized courts at the state levels than we have at the federal level. Judges at the state level are either appointed through some system, usually involving the governor, but in many states, at least some judges are elected. If you find that strange, you are in very good company. Many of us find it strange. We find the election of judges, and to some extent, the term appointments of judges to be somewhat in tension with the rule of law and the concept of the independence of the judiciary, but it is what it is. And I guess the most important thing to say about the state court systems is that the highest court in each state, which is often but not always called the Supreme Court of California, the Supreme Court of New Jersey, that court is the ultimate arbiter of state law. And so if I were a federal court judge interpreting and applying an issue of California law, I do not look at federal law, and I do not even look inside myself and say, what do I think is the right result? I look at what the California Supreme Court would do. I pretend for the moment that I am a judge on the California Supreme Court and do what I believe the California Supreme Court would do if it were deciding this particular case. I'm reaching now the final stages of the presentation. I want to just sort of introduce to you what it would feel like to go through the federal courts. First, you start almost always at the district courts, and the district courts, again, are the first instance courts, the trial level courts. Give me one second. Yes, then followed by that would be a visit to the Court of Appeals. Again, these are the intermediate appellate courts. You do have the right of appeal from the district court to the Court of Appeals. And as I mentioned earlier, courts of appeals hear some cases that come directly from agency decisions. And then obviously the Supreme Court. The Supreme Court is the federal court of last resort. And the Supreme Court has mainly discretionary review. And I want to talk a little bit about each of these processes in the slides that follow. So first, the district court, as you know, it is the first instance court in most cases. It is the trial court. This is when you watch an American movie or television and there's a courtroom scene, I would say 99% of the time, you're at the trial level court because that's where the fun stuff is. That's where you have the jury. That's where you have the presentation of evidence. That's really what the trial is the presentation of evidence. And so the jury, and I know that the jury system is, it's either not used at all in Brazil or it's used only in extremely serious criminal cases. But in the US, it's used all the time. It's used in civil cases, it's used in criminal cases. It's a fact of life in the US. And the jury's job is to figure out what the facts are. So the jurors will listen to the evidence presented and decide which version of those facts is correct, is most plausible. And they will apply those facts to an instruction that the judge gives them on what the law is. So it's the jury that applies the facts to the law as instructed by the judge. The judge, of course, is also charged with making rulings on evidentiary matters and procedural matters and things like that. And then, of course, you have the parties through their attorneys. We have what's called an adversarial system. And in our adversarial system, the parties do most of the work. As I alluded to earlier, the judge at the trial court level is relatively passive. The judge is not involved in the framing of legal issues. The judge is not involved in fact investigation or determination. All that is left to the parties. Next, again, we have the Court of Appeals. You appeal to the Court of Appeals in the circuit in which your district court sits, and this is a right. But the Court of Appeals reviews only legal issues properly preserved below. So you can't save issues for appeal and then bring it up on the Court of Appeals. They will not do that. And the Court of Appeals also will not consider whether the jury made a mistake with respect to facts. The Court of Appeals will only look for errors committed by the court, legal errors. What you have at the Court of Appeals will be a 3-judge panel. So there might be 20 judges on a Court of Appeals, but only 3 of them will be selected to hear a particular case. The parties will file briefs, which are advocacy, written forms of advocacy, and there will sometimes, but not always, be oral argument. What's great about right now is you could go to Courts of Appeals websites and listen to oral arguments that they've held during COVID. This was something that we did not have access to earlier. And it's very interesting to listen to oral argument, but honestly, the Supreme Court oral arguments are much more interesting. There's no evidence presented at the Court of Appeals. Why? Because the evidence was presented below. All the court on appeal is doing is looking to see whether the lower court committed reversible error. And they do that by looking at the evidence that is already in the record. Now, after your 3-judge panel review, there's a discretionary process called en banc review. And so it's sort of an appeal within the Court of Appeals itself. So you can ask for it as the losing party, but it is completely discretionary with the court, and you have no right to get en banc review. Likewise, you have no right to get review in the Supreme Court of the United States. And this is, the US system, I think, is very different from, I'm not sure I've ever known of any country that has as much discretionary jurisdiction in the highest national court as we do in the United States. Let me explain a little bit about how cases can get to the Supreme Court. First, the Supreme Court has a very small area of what's called original jurisdiction, cases that just go directly to the Supreme Court. For example, if New Jersey sues New York, goes directly to the Supreme Court. These cases almost never happen anymore. It's just not something we see very much anymore. There's also a small area of what's called mandatory appellate jurisdiction, where there's a statute that specifies that if a claim comes to the Supreme Court and it's properly brought under a particular statute, the Supreme Court has to hear it. This also is very, very, very small, very, very small area of mandatory appellate jurisdiction. Most cases come to the Supreme Court on what's called its discretionary appellate jurisdiction. And you get that through something called the writ of certiorari. The losing party below would file a petition for a writ of certiorari, and the justices decide. There are 9 justices on the Supreme Court. 4 of them have to decide that they want to hear the case. If 4 want to hear the case, they'll hear the case. If fewer than 4 vote in favor of the case, that's it, and you do not get an explanation. And so about 10,000 cases maybe come to the Supreme Court every year. The Supreme Court decides only about 80 or 85 cases in a typical year. Now, from the Brazilian perspective, that may seem outrageous because I know that the Brazilian Supreme Court and Constitutional Court have thousands and thousands and thousands of cases that they decide on the merits. So doesn't it seem unfair in the US that only 80 cases a year will be reviewed by the final judicial authority? Yes, it might be considered unfair, but the way we think about our Supreme Court is very different from the way many other countries view their Supreme Court. In many other countries, you view the Supreme Court as sort of the final protection against error. So you view the High Court as a court of error, of avoiding errors of law. We don't view the Supreme Court that way so much. We view the Supreme Court as a body designed to create consistency and uniformity among the federal courts. We have 9 justices and they sit on banc. So They will all hear all cases. As with the lower level court, they will only hear legal issues. They don't decide factual issues. The review is limited to the record below. There is no evidence at the Supreme Court. And again, they do their work through briefs and oral argument. Oral argument in the Supreme Court is very, very interesting. And there are very high-end recordings. I'll put it in the chat when I stop speaking, where you could get them. I have to just look up the link. But if you Google Oye, Oye, O-Y-E-Z, O-Y-E-Z, it will come up right away. And there are these very, very high-quality recordings of Supreme Court arguments. And that's all I want to say for now. Obrigada. And if you're interested in learning more about the US legal system, Martins Fontes has published a book of mine a few years ago, and it's a very basic introduction to the US legal system. I'm going to stop the share so that I can more easily see if you have questions or comments in the chat. I want to thank you all so much for being here, for having an interest in learning about the US legal system, and for taking some time on a weekend to hear my thoughts.
Obrigada a você, Tony. So yes, Tony has written a number of books, and they are very informative, of course, but the way she writes is very easy to grasp, you know. So, and her latest book, can you tell me the title again? Becoming a Lawyer, right?
Correct.
Becoming a Lawyer is a book on the soft skills and other skills lawyers must have in order to be successful. So she's already talked about it here with us. So so if you go to YouTube, it's the next video that we'll play. So Tony was here with us to talk about this book. I'll send you the link too, so you can watch this. Tony, before going to the audience's questions, I have a question for you. We all know that President Trump is a very conservative president. And you told us at the beginning of the webinar that the president of the United States gets to choose ultimately all the federal judges, right? Do you see a time of much more conservative decisions on the federal level in the next few years, because Mr. Trump obviously is picking conservative judges?
Yeah, Bruno, that's a great question, and something that someone like me spends a lot of time worrying about, because I don't, in case any of you is wondering, I'm not a Trump supporter. So we worry about this a lot. So let me explain how it works. So there are approximately, give or take, let's say 1,000 federal judges. There's 900 something, I don't remember the exact number. And so a president doesn't come in and get to replace all of them, because of course he has to wait until there's a vacancy. But yes, whenever there's a vacancy, a death, a retirement, an impeachment, which doesn't happen very often, every president gets to choose some number of judges, and that number is probably, you know, more than 100 and maybe as many as 200. So I do think, Bruno, over time, the selection of conservative judges and justices does signal a shift, and how it affects individual regions will depend on sort of the movement in that region. So if Obama, for example, let's say the Second Circuit, Obama got to make a whole bunch of picks for the Second Circuit, they're presumably fairly young, fairly healthy, and they're going to spend 20, 30 years on the court. But yeah, in regions in which Trump has, and it's an interesting thing to think about, and I don't know the answer to this, the geographic distribution of those appointments by Trump could make an impact. And I want to talk about the Supreme Court in a moment, which is, of course, what we really worry about. I will say, though, that the movement is not as dramatic, usually, as you might think, because they are cabined by precedent and stare decisis. And so usually they're pretty sophisticated scholars, but there are ways to move a court in a direction. And where you see that especially is in the Supreme Court. And so Trump has already been able to nominate 2 of the 9 justices. Now, if he wins re-election, which I know seems ridiculous, but it is possible, and it is probably more possible than I like to even acknowledge. I mean, who thought he was going to win the first election? Nobody. He is likely to have at least one more choice. And the 2 justices that are most likely to not make it another 5 years on the court are both progressives. So there's Ruth Ginsburg, who many of you have probably heard of, the notorious RBG, who's the sort of leader of the liberal branch right now, and a guy named Stephen Breyer, who's almost as old as she is. He's not quite as frail as she is, but we worry about him. Look, anything could happen to any of them, but it's most likely that there would be a liberal leaving the court. And if that happens and Trump gets one more pick, I think we're in for a pretty significant shift to the right that will probably last for many, 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 many decades. Because presidents now, given that federal judges have life tenure, presidents are incentivized to choose fairly young judges. So we don't see judges in their 20s like you might in some civil law systems. But it used to be that a Supreme Court justice would be appointed in his 60s. Then we saw, Bush started nominating, for example, Justice Roberts, I think was 49 or 50 when he was put on the court. Obama also chose young justices, and Trump will do the same. And so if there is another Trump appointment to the Supreme Court, I think we'll see a pretty significant shift in constitutional doctrine. And it's something that you really put your finger on it, Bruna. This is something that a lot of us are very worried about.
Yeah, I bet, because the change will if there is a shift to the right, the consequences could be horrible, right? For your democracy, your legal system, even to day-to-day lives of people. So I am very, very worried about it too. I imagine you Americans, right?
Yeah, and it's really true what you just said, Bruna, that the Supreme Court deals with sort of all the things that really matter to us. I mean, it only does maybe 80 cases a year, but they're things that matter so much. Federalism, individual rights, including abortion rights, are very much on the line. The so-called separation of church and state is very much on the line. Federalism, the power of the federal government to do things that protect us, is very much on the line. So that's the shift that I'm most worried about, is the Supreme Court.
Exactly. Okay, so let me take a look at the questions people may have. Okay, so when you were explaining about the selection process of federal judges in the US, Ana Luisa said, this process works very much like the one we have here in the choosing process for the judges on our Supreme Court. Yes, you're right, Ana Luisa. And Gio Lester said something very interesting. Yes, but it was set up, the system, right? The process was set up when life expectancy was much lower, 60 or so. It makes no sense, no sense now. It's a good point, isn't it?
It's a really good point. And you're right. I don't know what the life expectancy of a white man would have been back. Obviously, that's who they were thinking about at the time they drafted our Constitution. But it probably was something like 60 or 65. And so if you're nominated at the age of 30 or 40, you have 20, 25 years. But now we're talking about justices spending 40 or 50 years on the court. 50 is on the high end, but it could happen. And I think it is a really good point. And, there is a scholarly arm of people in the US who believe very seriously that the Constitution does not mandate life tenure. And many people believe, and I don't know enough about the history to know, but that there could be a retirement age imposed. But I always think through this. What happens? Let's imagine that Congress passes a law that says federal judges must retire at age 70. Some federal judge who approaches age 70 will challenge this. And the case will go to the federal courts. And the federal courts will say, no, it means absolutely life tenure. It's hard to imagine the federal court saying something different. But I think whoever made that comment, that is very, very perceptive. Do we really want 90-year-olds on the federal court? Sometimes it works very well. Justice Stevens was very, he passed away, unfortunately, within the last year or so. He was very, very sharp and very agile at 90. But my friend who was 94, 95, honestly, he'd been hard of hearing for 20 years. He wasn't as with it as you would want. And do we really want no movement in a position for that period of time? On the other hand, the countervailing concern is so crucial, and that's the issue of independence. And so, you know, how old is the retirement age in Brazil for judges?
At the Supreme Court level, I guess it's 75.
75. 75 is okay. But, you know, in some countries, it's like 65. Okay, so I'm 59 years old, and I think, 65? You want me to retire at 65? Are you kidding?
Exactly, yeah.
So then I'm going to have to look for another job. I'm going to want to do something, and that, at least in theory, compromises my independence. 75 sounds like an okay age, though, but that's a really interesting point that our colleague made.
Exactly. All right, and a lot of people thanking us. Extremely informative and educational, helps us think better about so much. When is the next one? There will always be a next one here with Tony.
I hope so.
Just fabulous. Congratulations. Thank you, Tony and Bruna. Extremely clear class. Great webinar. Excellent content. I especially liked the language used in the field, as in arise under and others. Eduardo, who's a student of ours, congratulations for both, for this initiative. Great class, Tony, thanks a lot. And a lot of people. And a last question. Regarding contract law, how does the diversity rule apply between two different states concerning jurisdiction attribution for federal courts? Marta has asked you that.
Do you mean the choice of substantive law in those cases?
Marta, can you be more clear, please? Tony, there's a 20 to 30 second delay on YouTube, but so let's wait for a few seconds. Thanks, Bruno and Tony. Thank you, guys. Sueli, great webinar. Let's see if we can get Marta to clarify her question.
I can answer the question. Sorry.
Sure, go ahead. No, go ahead.
I'm going to answer the question I think Marta's getting at. So if you have a citizen of New York and a citizen of New Jersey, which substantive law applies? And that's a really interesting question. And that's a different question, totally different from which court do you go to. So we could end up, let's say, a citizen of New York, a citizen of New Jersey, have a dispute. It could be that we end up in a federal court in New Jersey, or even a state court in New Jersey, but that New York law will apply. So they're pretty separate considerations. And the choice of law will either be established by contract. So just a word of advice, if any of you is doing a contract with a party in the US, make sure you include a substantive choice of law provision, or you'll be very, very sorry that you're wasting then 5-10 years figuring out choice of law. And in a situation in which there's no choice of law, you usually look at the law with the most interest in or connection with the litigation. Oddly enough, the choice of law analysis will be different state by state, but it will usually look at something like which law has the most interest in or connection to the litigation. So let me just give you an example. For example, let's say that a citizen of New York is driving south, and a citizen of Florida is driving north, and they have a car accident in North Carolina. North Carolina will absolutely apply, because North Carolina has the most significant interest and connection to that particular litigation.
Excellent. And one last comment, they want a course on American law with you. So we should think about it and talk about it.
Good. And also, Fordham is now starting to offer some online offerings.
Great.
So, one thing, and Bruna, you and I have talked about this, will be the Legal English Institute that is going to be online. We're starting next week, Tuesday, but we're also going to do it online starting in January. So anyone who's interested should feel free to reach out to me. You can also just Google Fordham Legal English Institute. Bruna also knows all about this. I don't want to give you more work, Bruna, but if people write to you, you could either just direct them.
Of course. Yes, of course. Yeah.
By the way, Bruna, I would invite everyone to connect with me on LinkedIn. I would love that.
Exactly.
And we're in touch with each other that way.
Well, at least COVID is giving us a chance, right, to study at Fordham.
It's a silver lining. I think we're all more comfortable. Like Bruna, in the past, we've talked about me coming to Brazil and it was so complicated and this and that.
Exactly.
And this is so easy. We wake up, we put our computers on and we're together. And I think that's a silver lining. And Bruna, that's one of the things I've always loved about you is you're always so upbeat and happy and always looking on the bright side. And that is, from my other book on becoming a lawyer, that is such an important attribute in a professional.
That's true. That's true. Thank you, Tony. Thank you very much for your time, for your inputs. They were very valuable. So for everyone who has enrolled, I'm going to send you guys the recording of this class. And I'll send them the link to the Legal English Institute. Is that okay with you, Tony?
Perfect.
Okay. And then if you guys have any questions, you can contact me. I contact Tony and you can talk more about it. So thank you very much, everyone, for your time. Thank you, Tony, again. See you next time.
Thank you, everyone.